Mr. London. Mr. Speaker, today the Chief Executive sent to this House of Representatives a banking bill for immediate enactment. The author of this bill seems to be unknown. No one has told us who drafted the bill. There appears to be a printed copy at the Speaker's desk, but no printed copies are available for the House members. The bill has been driven through the House with cyclonic speed after 40 minutes debate, 20 minutes for the minority and 20 minutes for the majority. I've demanded a roll call, but have been unable to get the attention of the chair. Others have done the same, notably Congressman Sinclair of North Dakota and Congressman Bill Lemke of North Dakota, as well as some of our other former labor members. 15 men were standing, demanding a roll call, but that number is not sufficient. We therefore have the spectacle of the great House of Representatives of the United States of America passing, after a 40-minute debate, a bill its members never read and never saw, a bill whose author is unknown. The great majority of the members have been unable to get a minute's time to discuss this bill. We have been refused a roll call, and we've been refused recognition by the chair. I do not mean to say that the Speaker of the House of Representatives intended to ignore us, but everything was in such a turmoil and there was so much excitement that we simply were not recognized. I want to put myself on record against a procedure of this kind and against the use of such methods in passing legislation affecting millions of lives and billions of dollars. It seems to me that under this bill, thousands of small banks will be crushed and wiped out of existence, and that money and credit control will be still further concentrated in the hands of those who now hold the power. It is safe to say that in normal times, after careful study of a printed copy and careful debate and consideration, this bill would never have passed this House or any other House. Its passage could be accomplished only by rapid procedure, hurried and hectic debate, and a general rush for voting without roll call. I believe in the House of Representatives. I believe in the power that was given us by the people. I believe that Congress is the greatest and most powerful body in America, and I believe that the people have vested in Congress their ultimate and final power in every great, vital question, and the Constitution bears me out in that. I'm suspicious of this railroading of bills through our House of Representatives, and I refuse to vote for a measure unseen and unknown. I want the record to show that I was and am against this bill and this method of procedure, and I believe no good will come out of it for America. We must not abdicate our power to exercise judgment. We must not allow ourselves to be swept off our feet by hysteria, and we must not let the power of the executive paralyze our legislative action. If we do, it would be better for us to resign and go home and save the people the salary they are paying us. I look forward to that day when we shall read the bill we are considering and see the author of the bill stand before the House and explain it. And then, after calm deliberation and sober judgment, after full and free debate, I hope to see the sane and sensible legislation passed which will lift America out of this panic and disaster into which we were plunged by the World War. Disclaimer. The material in this essay is for educational purposes only, and not to be construed as legal advice about what you should or should not do. The information herein is to assist you in performing your own due diligence before implementing any strategy. In this article, we will examine the evidence that the United States government is in bankruptcy and the implications for all Americans. Before we begin to trace the events demonstrating that the bankruptcy exists, allow me to quote from a fairly recent congressional record. Mr. Speaker, we are here now in Chapter 11. Members of Congress are official trustees, presiding over the greatest reorganization of any bankruptcy entity in world history, the U.S. government. We are setting forth, hopefully, a blueprint for our future. There are some who say it is a coroner's report that will lead to our demise. Republican James Traficant, Jr., Ohio, addressing the House Congressional Record, March 17, 1993, Volume 33, page H-1303.
It's time, gentleman from California.
Mr. Speaker, for purposes of debate only, I yield 5 minutes to the gentleman from Ohio, Mr. Traficant.
The gentleman from Ohio is recognized for 5 minutes without objection.
We are here now in Chapter 11. Members of Congress are official trustees presiding over the greatest reorganization of any bankrupt entity in world history, the U.S. government. Members of Congress are official trustees presiding over the greatest reorganization of any bankrupt entity in world history, the U.S. government. Members of Congress are official trustees presiding over the greatest reorganization of any bankrupt entity in world history, the U.S. government. We are setting forth, hopefully, a blueprint for our future. There are some that say it's a coroner's report that will lead to our demise.
Events demonstrating the bankruptcy. If in fact a bankruptcy exists, one would expect to find evidence of it in our various government records. The evidence from these sources suggests that the bankruptcy was precipitated by the stock market crash of 1929. So we will begin our search here. In 1929, the United States entered the Great Depression. At that time, most of the major economic and military powers in the world were also in the Depression. You may recall that Americans were permitted to own gold and that our currency was backed by gold and silver. People could deposit their gold in Federal Reserve banks, and the bank would give them a note which they could use to withdraw their gold. Due to the panic in the economic markets after the crash of 1929, people were trying to withdraw the funds from the banks in the form of currency, silver and gold. President Herbert Hoover asked the Federal Reserve Board of New York for a recommendation on how to deal with the situation. One might wonder why President Hoover would ask the Federal Reserve for advice. But a review of the Federal Reserve article will show that the Federal Reserve was in control of our monetary policy. The Federal Reserve Board adopted a resolution to respond to President Hoover's request. Resolution adopted by the Federal Reserve Board of New York. Whereas in the opinion of the Board of the Directors of the Federal Bank of New York, the continued and increasing withdrawal of currency and gold from the banks of the country has now created a national emergency. Herbert Hoover, Private Papers of March 3, 1933. The Federal Reserve Board is stating that the run on the banks is causing a national emergency. Since our currency was backed by gold, why would it cause a national emergency for the people to hold the gold rather than the banks? To find the answer, let's see what President Hoover had to say. That those speculators and insiders were right was plain enough later on. This first contract to the money changers with the New Deal netted those who removed their money from the country a profit of up to 60% when the dollar was debased. Hoover policy paper written by the Secretary of Interior and Secretary of Agriculture. President Hoover is saying that those with inside knowledge had already removed the money, gold, from the country before the American people started demanding their money from the banks. Since the banks didn't have the gold the people were demanding, the banks needed protection. So, the Federal Reserve Board went on to propose that the President issue an executive order based upon the Trading with the Enemy Act of 1917 as follows. Whereas it is provided in Section 5B of the Act of October 6, 1917, as amended, that the President may investigate, regulate, or prohibit under such rules and regulations as he may prescribe by means of licensure or otherwise any transaction in foreign exchange and the export, hoarding, melting, or earmarking of gold or silver coin or bullion or currency. Herbert Hoover, Private Papers of March 3, 1933, emphasis added. President Hoover declined to issue the order, but Franklin Delano Roosevelt was inaugurated as president on March 4, 1933. In his inauguration speech, he requested that Congress grant him emergency powers equal to those he might have in times of war to allow him to deal with the crisis.
I am prepared, under my constitutional duty, to recommend the measures that a stricken nation in the midst of a stricken world may require. These measures, or such other measures as the Congress may build out of its experience and wisdom, I shall seek within my constitutional authority to bring to speedy adoption. But in the event that the Congress shall fail to take one of these two courses, in the event that the national emergency is still critical, I shall not evade the clear course of duty that will then confront me. I shall ask the Congress for the one remaining instrument to meet the crisis: broad executive power to wage a war against the emergency, to wage a war against the emergency, to wage a war against the emergency, as great as the power that would be given to me if we were in fact invaded by a foreign foe.
On March 5, 1933, he issued Proclamation 2038 requesting a special session of Congress beginning on March 9, 1933 to deal with the banking emergency. Then on March 6, 1933, President Roosevelt issued Proclamation 2039 to indicate to Congress what kind of emergency powers he was asking for. This proclamation had exactly the same wording as that proposed by the Federal Reserve Board, but the proclamation had not authority until Congress met to give him the required authority.
I wanted to pause right here and bring something to all the viewers' attention as it relates to Franklin Delano Roosevelt. You know, I did some research on this man after, watching a video called Hitler, the Greatest Story Never Told, which I highly suggest that everybody watch if you want to kind of see the other side of the story as it relates to World War II, World War I, the Balfour Declaration, and find out what's going on in Palestine, how, the Jews got in Palestine and so forth. It was a very enlightening video for me to watch. But in addition, it made me start to think, after watching that video, is it just to what extent the Jews had an influence on the war. And I did a little investigation on Franklin Delano Roosevelt because I wanted to check out to see if he was a Jew. And it seems to be pretty veiled. He says he don't know what he is and so forth. But his nationality seems to be veiled. But what I did find out that was interesting, that he had appointed like 73 different Jews in his administration. 73 of them. I thought that would just be a tidbit of interesting information for all the viewers when you stop and think about the New Deal, when you think about Leviticus 25:45, putting people in slavery with debt, the advent of the welfare state, just all of these different things. And I hate to sound anti-Semitic. It's like it's making me sound anti-Semitic or something. But I mean, these are just things you can verify for yourself. It's just everywhere you turn around, there seems to be a Jewish involvement in all of this. And it's just hard to ignore and hard to deny. I'm just simply pointing out the facts, and just wanting people to take note of it. You can go ahead and do your own research, but here's a list. You can see the list right here of 73. I thought it was 72 because 72 is a mystical number. They had 73 on here, but I thought it was 72 different people he had appointed to his cabinet. And you can see the list right here. But I just wanted to stop and just bring that to your attention. I think it would just be an added piece of information to share with my audience so they would know.
One might well ask how the Federal Reserve Board could make such influence over the president. Some researchers speculate that the Depression was engineered by the Federal Reserve and the international bankers that they represent. See our article on the Federal Reserve for more information about the link between the Federal Reserve and international bankers. The bankers' motive was to further consolidate, they already controlled the monetary policy of the United States, their power. It is also speculative that the government was told that it could cooperate with the Federal Reserve, international bankers, or the depression would remain indefinitely. Under such political blackmail, the President, Congress, and courts were willing to acquiesce to the demands of the bankers.
Bear these speculations in mind as you read how quickly the Federal Reserve got what it wanted.
Those speculations will be an arena for further research. The first act passed by Congress when they met in special sessions has the following preamble. Be it enacted by the Senate and the House of Representatives of the United States of America and Congress assembled, that the Congress hereby declares that a serious emergency exists, and that it is imperatively necessary speedily to put into effect remedies of uniform national application. On the first day of the special session, Congress approved Proclamation 2039. On the same day, President Roosevelt reissued it as Proclamation 2040. Whereas, under the Act of March 9, 1933, all proclamations heretofore or hereafter issued by the President pursuant to the authority enforced by Section 5B of the Act of October 6, 1917, as amended, are approved and confirmed. President Roosevelt's Proclamation 2040. On that same day, Congress passed the following statute. During time of war or during any other period of national emergency declared by the President may, through any agency that he may designate or otherwise investigate, regulate or prohibit under such rules and regulations as he may prescribe by means of licensure or otherwise, any transaction in foreign exchange, transactions of credit between or payments by banking institutions as defined by the President, and export, hoarding, melting, or earmarking of gold or silver coin or bullion or currency by any person within the United States or any place subject to the jurisdiction thereof. Title 1, Section 2, 48 Statute 1, March 9, 1933. This is exactly the same language that was found in the 1917 Trading with the Enemy Act, with the exception of the section in bold. The exclusion of transactions within the United States had been removed from the Act. This statute can now be found in the United States Code at 12 U.S.C. subsection 95B. This is the current version of the statute. Notice that the wording is almost identical to that found in the 1933 statute shown in above paragraph. Section 95B, ratification of acts of President and Secretary of the Treasury under Section 95A. The actions, regulations, rules, licenses, orders, and proclamations heretofore or hereafter taken, promulgated, made, or issued by the President of the United States or the Secretary of the Treasury since March 4, 1933, pursuant to the authority conferred by Section 95A of this title, are approved and confirmed. 12 U.S.C. subsection 95B. This version says that the authority is granted in 12 U.S.C. subsection 95A. But if you look at the notes to that statute, you will see that the original source authority is located in October 6, 1917, Chapter 106, Section 5B, 40 Stat 415. And later in March 9, 1933, Chapter 1, Title 1, Section 2, 48 Stat 1. So the President still has the authority as it was originally granted in 1917 and later modified in 1933. The effect of this emergency power is that all Americans are now part of the Trading with the Enemy Act as amended in 1933. The significance of this change will become apparent shortly. Since the banks didn't have gold to pay out, President Roosevelt used Proclamation 2039 and 2040 along with the provisions of 12 U.S.C. subsection 95B to create a banking holiday. This can be verified if we read the definition for banking holiday of 1933. Bank holiday of 1933. Presidential Proclamation number 2039 issued March 6, 1939, and number 2040 issued March 9, 1933. Temporarily suspended banking transactions by member banks of the Federal Reserve System. Normal banking functions were resumed on March 13th, subject to certain restrictions. The first proclamation, it was held, had no authority in law until the passage of March 9, 1933, of a ratified act, 12 United States Code annotated subsection 95B. The present law forbids member banks of the Federal Reserve System to transact banking business except under regulations of the Secretary of the Treasury during an emergency proclaimed by the President, and 12 United States Code annotated subsection 95. Black's Law Dictionary, 5th edition, emphasis added. The restrictions mentioned in the above definitions are that the banks had to be licensed before they could be reopened. A license is something which grants authority to do something that would otherwise be illegal. Trading or conducting business with the enemy, Americans or American soil, was made an illegal activity unless licensed. President Roosevelt's papers revealed that the government will grant the license. The Secretary of the Treasury will issue licenses to banks which are members of the Federal Reserve System for the national bank or state located in each of the 12 Federal Reserve Bank cities to open Monday morning. President Roosevelt's papers. Another provision passed on March 9, 1933, gave Federal Reserve agents the authority to act as agents of the U.S. Department of Treasury. This seems very strange since the Federal Reserve is a private business.
Thank you, Justice Scalia and Justice Breyer, for joining us. It's an honor to have you here today. But for you personally, looking at it, notwithstanding the fact that it's more efficient, notwithstanding the fact that you do have bicameral passage and you have presentment of this hypothetical law, the problem is that you have delegated the lawmaking power.
Exactly.
Exactly.
You have to be careful because John Jay, I just read this in John Stevens' book, is pretty good. The first chapter, he says, John Jay, first Chief Justice. And George Washington went to him and said, I have a lot of questions here. I don't want to do anything unconstitutional. Here are a bunch of them. Will you answer them? And John Jay said, no advisory opinions. He said, we're not giving any advice. But the real reason, of course, is he didn't know the answer.
I had to pause right here because this is a part that you really need to pay attention to. You see, when you're not educated about politics and law and so forth, conversations like this will get right past you. If you don't know who John Jay is, the first Supreme Court Justice, why they don't like John Jay. You're going to see in a while this senator, he doesn't like him. He's going to have a little sarcastic remark for him and so forth. Why all of this is going on in these conversations. Why did Supreme Court Justice Breyer stop the conversation? Whoa, let's not talk about that. He don't really know. Well, did he not know? Something very interesting. You can get a copy of Supreme Court the analysis and interpretation of the Constitution by the Supreme Court. And on page 599, there's something very interesting. And I'm going to preference what I'm going to say by this. There are two Supreme Courts. There is a Supreme Court of the United States of America, and then there's the United States Supreme Court. One is they're both Article 3 because they have Article 3 judges sitting on the bench, but they act in different capacities. The United States Supreme Court is receiving a delegation of authority from the Congress to do a judicial review of the decisions they make in Article 1 courts, while a Article 3 court is primarily constituted to adjudicate private rights. And they'll tell you this straight up. If anybody wants to challenge me on this, I can show you it straight up. They'll tell you that that Article 3 courts, they delegate, they are there to adjudicate private rights. Now, there was a very interesting letter from John Jay, and you can read it right here in the footer on page 599 when it's talking about inferior courts. They make this thing between Article 1 courts and Article 3 courts very murky. You can read articles from professors of law and everybody's trying to figure it out because they don't want anyone to understand the distinction between these territorial courts and Article 3 courts. They don't want you to know where you locate your rights and how to get out. The people should be demanding that they make this distinction clear, but they're not. But even back then, Chief Justice Jay had a question about it from George Washington. You can see right here in footer 21 when they're talking about inferior courts and it's talking about the Judiciary Act. And all you guys out there, y'all, I see so many people talking about the Judiciary Act. This is an act, man. An act didn't create the Supreme Court. The Constitution created the Supreme Court. This act is what created the Supreme Court of the United States Supreme Court. It didn't create the Supreme Court of the United States of America. You guys got to know this stuff. You got to know the difference in these in grammar and everything to see what these people are doing. Okay, and you read it right here in inferior courts. Congress also acted in the Judiciary Act of 1789 to create inferior courts. Okay, and they get the authority of that from Article 1, Section 8, Clause 9. Okay, 13 district courts were constituted to have 4 sessions annually, and 3 circuit courts were established to consist jointly of 2 Supreme Court justices, each in one of the district judges of such districts, which were to meet twice annually in the various districts comprising the circuit. This system had substantial faults in operation, not the least of which was the burden imposed on the justices, who were required to travel thousands of miles each year under bad conditions. Now, right here you're going to see this footer 21, which is a very, very interesting footer. And you can see about what what this conversation that he was just having about George Washington is right here. And you can see it right here. It says, upon receipt of a letter from President Washington soliciting suggestions regarding the judicial system, writings of George Washington, J. Fitzpatrick edition, okay, Chief Justice Jay prepared a letter for the approval of the other justices, declining to comment on the policy questions. Okay, that's what he was talking about. He didn't know the answer. Okay, he just declined to comment, but raising several issues of constitutionality. They forgot to bring this part in, that the same man should not be appointed to 2 offices, that the offices were incompatible, and that the act invaded the prerogatives of the President and the Senate, which are the political branches of government. Okay, these are they receive a delegation of authority from Article 1. They receive a delegation of authority from Article 2, and of course the judiciary receives a delegation of authority from Article 3. And you have what is called separation of powers, and this is what he's referring to, that this act, which he's talking about, this Judiciary Act, invaded the prerogatives of the President and the Senate, because here you are trying to create this United States Supreme Court and have these justices sitting on that bench, and they're asking questions. You say, okay, well, how are you going to have 2 the same man being appointed to 2 offices, and that the offices were incompatible, and that the act invaded the prerogatives of the President and the Senate? And this is just Chief Justice John Jay asking this question, and this is why they don't like John Jay. They don't like him. They also don't like him because they all were saying, hey, the people are sovereign. These original Supreme Court justices were letting everybody know we're sovereign, but you got all these idiots out here calling us sovereign citizens. We don't know what we're talking about. You need to go and study the first Supreme Georgia, Chisholm versus Georgia. I got videos up on it. You got to understand these things. But this is what they're referencing, and you need to understand that. You need to get the full story of what's going on. The whole point of them having this meeting right now is that Congress has called the Supreme Court justices in to ask them probably for some questions on, on things that they would do in regards to delegating. You got to understand delegation of powers doctrine, delegating a portion of the legislative power to private entities. Okay, which, of course, the justices say, well, okay, this is unconstitutional what you're doing. They do things that are unconstitutional all the time because the people are ignorant, as well as the fact that they don't understand the jurisdiction that the Congress is acting in, which is outside of the Constitution, because they are conducting everything through contracts. But the people need to wake up and see what's going on. They're going to eventually wake up. You're going to see what's going on, because I'm going to keep giving you this information, and you're going to keep on researching on your own, because I'm showing you it right here in black and white that Chief Justice Jay was questioning it back then. How are you having one man appointed to 2 different offices? This is what you hear a lot of people in the movement. They say that the judges wear 2 hats. They wear Article 1 hat and they wear Article 3 hat. This is how you come in and they'll say, well, okay, well, he is an Article 3 judge, or yeah, he is an Article 3 judge, but he's not. You don't have an Article 1 hat. They're operating under an Article. He don't have an Article 3 hat on. He's operating from a delegation of authority from Article 1.
And he was right. And he was right. And his tenure on the court proved to be short-lived in any event.
In case you didn't catch that, that was a little jab that he threw at Chief Justice Jay. In any event, his tenure on the court was short. You can just see it. Now you understand why he made that statement. They don't like those guys because they were cutting into their power. He said, hey, the people are sovereign, and they're like, nah, we got the power, but we're sovereign. The state is sovereign. This is what you're dealing with, y'all. These are the people you're putting in office.
Now, the situation you pose is quite different, of course, from your leaving it to an agency
So how is it different then? How do those differ?
Well, because when you leave it to an agency, you are giving it to the executive. The executive can make rules. You can't run an executive operation without making rules. The doors open at 8 o'clock. If you're the Interior Department, you can't have fires on public land. You can graze private cattle on. It's up to the agency to make rules. But there is an obstacle that discourages you from giving too much power to the executive agency because you are increasing the power of the president. You're a competitor to the president. You know, the separation of powers with different branches competing.
And this is a very important part I want you to pay attention to. Notice he was talking about separation of powers and how that you can delegate. There is a delegation of powers doctrine. The legislature can delegate a portion of their power to the executive. All the agencies are under the executive branch of government. However, but you can't delegate too much power. You can't delegate the lawmaking power to those agencies because the Constitution doesn't allow for that. They do have rule-making ability. They can make the rules for the running of the agency, but you can't delegate all their explicit power over to that agency. And he can do that, and he can't do too much because it's separation of powers. You gotta always remember separation of powers. Separation of powers is so important for people to understand, to make sense of all of this. How the Congress is doing what they're doing, how they are at times attempting to operate outside of their delegation of authority, how they are bamboozling everybody into contracting with them to operate outside of the Constitution as a United States citizen and so forth, to forego your private rights and to, fall in line with this welfare type of society instituted by FDR and his administration and so forth. People need to wake up, and you need to understand what it means to be free and independent. You need to stop depending on government. You don't need nothing from government. The only duties government has is to protect your borders and protect your property and your life and liberty. That's it. When you start doing anything else with the government, you're contracting for services. And when you take advantage of a benefit or a privilege from government, you take on the corresponding liability associated with it.
And there is no such disincentive when you leave it to this private group that you're talking about. That is just a pure delegation of legislative power. You are not authorizing an executive to act like an executive, but you are delegating legislative power to a group that has no executive responsibilities.
And here is the point. When we get back to what we were just discussing about the Federal Reserve, which is a private corporation or private trust that has received a delegation of power from Congress via the Federal Reserve Act, and it is a private entity, but somehow, some way, they're in control of the monetary policy of the country. But yet people want to say the United States is not bankrupt, but they can't explain who this Federal Reserve is and who these people are. And why we have Federal Reserve notes. They tell you because there's actually people out there saying that the country is not bankrupt and trying to act like that, when all you have to do is look at a Federal Reserve note and see it's a promissory note. Where's the money at? Who is the Federal Reserve? Answer these questions. When required to do so by the Secretary of the Treasury, each Federal Reserve agent shall act as an agent of the Treasurer of the United States or of the Comptroller of the Currency, or both, for the performances of any functions which the Treasurer or the Comptroller may be called upon to perform and carrying out the provisions of this paragraph. 48 Stat 1, emphasis added. We've already seen that insiders have removed most of the gold from the banks before the American people started demanding their money from the banks. Since the banks didn't have the money the people were demanding, the banks needed protection. In order to do this, the American people had to be declared the enemy. The Trading with the Enemy Act, as revised in 1933, accomplished this. Then Congress passed a statute which authorized stiff fines and/or prison sentences if the people didn't turn in their gold. Whenever, in the judgment of the Secretary of the Treasury, such action is necessary to protect the currency system of the United States, the Secretary of the Treasury, in his discretion, may regulate any or all individuals, partnerships, associations, and corporations to pay and deliver to the Treasurer of the United States any or all gold coin, gold bullion, and gold certificates owned by such individuals, partnerships, associations, and corporations. Whoever shall not comply with the provisions of this act shall be fined not more than $10,000, or if a natural person may, in addition to such fine, be imprisoned for a year, not exceeding 10 years. Stat 48, Section 1, Title 1, Subsection N, March 9, 1933. So not only were American citizens not able to get their gold, but their gold was confiscated by the government. Since all money was gold and silver certificates and all of the money had to be turned in, the people were left without any money. During this banking holiday, it was at first believed that some form of script or emergency currency would be necessary for the conduct of ordinary business. We knew that it would be essential when the banks reopened to have an adequate supply of currency to meet all possible demands of depositors. Consideration was given by government officials and various local agencies to the advisability of issuing clearinghouse certificates or some similar form of local emergency currencies. On March 7, 1933, the Secretary of the Treasury issued a regulation authorizing clearinghouses to issue demand certificates against sound assets of the banking institutions. But this authority was not to become effective until March 10th. In many cities, the printing of these certificates was actually begun. But after the passage of the Emergency Banking Act of March 9, 1933, 48 Stat 1, it became evident that they would not be needed because the act made possible the issue of the necessary amount of emergency currency in the form of Federal Reserve Bank notes, which could be based on any sound asset owned by the banks. Roosevelt's papers, emphasis added. So we see that Roosevelt's papers admit that the Emergency Banking Act made it possible to issue emergency currency which was based upon the assets of the bank rather than upon gold or silver. Remove the U.S. from the gold standard. The emergency currency was Federal Reserve Bank notes. Federal Reserve notes are still used today. Next, we will see what was to be used to back up the Federal Reserve Bank notes. Upon the deposit with the Treasury of the United States, A, of any direct obligations of the United States, or B, of any notes, drafts, bills of exchange, or bankers' acceptances acquired under the provisions of this act, any Federal Reserve Bank making such deposit in the manner prescribed by the Secretary of Treasury shall be entitled to receive from the comptroller of the currency circulating notes in blank, duly registered, and countersigned. Emergency Banking Act of March 9, 1933, Section 4, Public Law 89-719. Later, in 1933, the House of Representatives passed a joint resolution to suspend the gold standard and abrogate the gold clause, which says in part that A, every provision contained in or made with respect to any obligation which purports to give the obligee a right to require payment in gold or a particular kind of coin or currency, or in as amount of money of the United States measured thereby, is declared to be against public policy, and no such provision shall be contained in or made with respect to any obligation hereafter incurred. House Joint Resolution 192, June 5, 1933, emphasis added. Since this measure was passed as a joint resolution, it does not have the force of law. You will notice that the resolution uses the term public policy. We frequently hear the term public policy used, but what does it mean? Policy, the general principles by which a government is guided in its management of public affairs. Black's Law Dictionary, 7th edition. Public policy, broadly, principles and standards regarded by the legislature or by the courts as being of fundamental concern to the state and the whole of society. Black's Law Dictionary, 7th edition. Public policy is not the same thing as public law. Public law, the body of law dealing with the relations between private individuals and the government, and with the structure and operation of the government itself. A statute affecting the general public. Black's Law Dictionary, 7th edition. This is a rather startling admission on the part of Congress. They are saying that what they are doing by refusing to pay the federal debt in gold is not according to the law, but rather a public policy. So we see that the currency was no longer backed by gold, even if it is only public policy. The new currency was Federal Reserve Bank notes. These notes were and still are backed by direct obligations of the United States, which are Treasury notes. They are also backed by bank notes, drafts, bills of exchange, and bankers' acceptances. This last group are notes, loans that Federal Reserve member banks were holding on loans they had made to people and institutions. So the public or private debt instruments of the bank were considered assets to be deposited in the Treasury in exchange for circulating notes. This can be further proven by excerpts from the congressional record during the debate over the Emergency Banking Act of 1933. Mr. McFadden, Mr. Speaker, I regret that the membership of the House has had no opportunity to consider or even read this bill. The first opportunity I had to know what this legislation is was when it was read from the clerk's desk. It is an important banking bill. It is a dictatorship over finance in the United States. It is complete control over the banking system in the United States. It seems to me that the casual reading which I have given to the bill indicates clearly that if banks are permitted to open tomorrow morning, only those banks which do open will be permitted to operate. Other banks that do not open tomorrow morning will be opened under a limited receivership or a receivership. It is a protection for the solvent banks of the United States first. Of course, it may be that the banking system is in such shape that it is necessary to deal with it in this manner. I've been calling attention for some years past to the manner in which the Federal Reserve System has been conducted, and have predicted that it would lead to this kind of a situation. We have, step by step, been proceeding along the lines of centralization. Attempts in past meetings of this Congress have succeeded in enacting increasingly centralized banking plans. This gives supreme authority to those people who have wanted to control the finances of this government through a centralized system to have such a system. I wish and I hope for the new administration all success. No one wants the new administration under the leadership of President Roosevelt to succeed any more than I do. I shall go as far as any other man to see that success comes to it. But I say now to that leadership that the first thing that must be done is to audit the United States Treasury. We want to know, the people of the United States want to know, the condition of the public treasury and the obligations that are outstanding. We want to know the amount of gold in the United States Treasury, and we want to know the amount of gold in the Federal Reserve System. We want to know the total amount of outstanding government obligations. This is a time to draw a line. And may I say to you Democrats here that if you do not draw a line through the Treasury operations now and the federal operations, you will be enmeshed in all the things that they have been doing. And they have been doing some things, as I pointed out heretofore, or we should not be in the condition we are in today. I want to know, so far as I'm concerned, that the bill represents the ideas of the new administration, the New Deal. I shall help to carry it through if it is that. If, on the other hand, this bill has been proposed and written by the same influences that are responsible for this financial situation, I shall fight it and do everything that I can to defeat it. It seems to me there is authority here to continue the Federal Reserve operations under the same management, and it seems to me I can see much in this bill that can be abused and that may have been dictated by the same banking influences that are responsible for our present predicament. I hope this is not so. But I do not want to impress upon this House and upon the administration the importance of going to the bottom of this situation. This situation demands a house cleaning. Confidence in this country will not be restored until the people of the country know the condition of the United States Treasury and the condition of the Federal Reserve banks. It is difficult under the circumstances to discuss this bill. The first section of the bill, as I grasp it, is practically the war powers that were given back in 1917, with some slight amendments. The other gives supreme authority to the Secretary of the Treasury of the United States to impound all the gold in the United States in the hands of individuals, corporations, or companies for the purpose, I suppose, of bringing together that gold and making it available for the issuance of Federal Reserve notes. The third section deals with how banks are to be handled under this authority, how banks' assets are to be frozen, and deals with the question of limited receiverships and receiverships. The last section of the bill provides for the issuance of a new money. I'm a little at loss in the hurried way I have had to read the bill to understand just how this new money is to be handled. I refer to Section 401, which reads, upon deposit with the Treasurer of the United States of all contract obligations of the United States or any notes, and so forth. Under the Federal Reserve Act, obligations that are deposited as the security and gold for reserve notes are placed in the hands of the Federal Reserve agent. I would like to ask the chairman of the committee if this is a plan to change the holding of the security back of Federal Reserve notes to the Treasury of the United States rather than the Federal Reserve agent. Mr. Stegall, this provision is for the issuance of Federal Reserve bank notes, not for Federal Reserve notes, and the security back of it is the obligations, notes, drafts, bills of exchange, bank acceptances outlined in the section to which the gentleman has referred. Mr. McFadden, then the new circulation is to be Federal Reserve bank notes and not Federal Reserve notes. Is that true? Mr. Stegall, insofar as the provision of this section are concerned, yes. I would like to ask the gentleman right in that connection, is there any gold reserve to be held as security back of these new Federal Reserve bank notes? Mr. Stegall, the law provides 5% back of Federal Reserve bank notes, just as is maintained in case of national bank notes. There have been issued a small amount of these notes. I cannot recall the exact figures. The gentleman is probably more familiar with it than I am. There's only a little of that currency outstanding. This contemplates a substantial addition to it. It is a liberalization of currency issue to take care of banks in their efforts to respond to the demands of business and liability to their depositors. Mr. McFadden, the current press reports indicate that there will be issued under this authority some 2 million or more of new currency and made available to the banks. Is that correct? Mr. Stegall, to be frank with the gentleman, I should not like to be bound in my answer by estimates outlined in newspaper reports. The issue might greatly exceed the amount suggested. Mr. McFadden, will the gentleman say how much it is possible to be issued or is contemplated to be issued? Mr. Stegall, no one knows. It is not an arbitrary expansion. The purpose is to provide an elastic expansion to meet the exigencies and development of banking and business conditions. Mr. McFadden, I think it is fairly clear from the colloquy that has just taken place that the increased Federal Reserve circulation is to be in the form of Federal Reserve bank notes and not the present Federal Reserve notes that are in circulation to the extent of approximately $4 billion, which are secured by 60% of eligible paper of government bonds and 40% of gold. This is a new issue which is authorized under the Federal Reserve Act, which has not to any great extent been resorted to heretofore. When you read this, you can see these guys, they didn't even get a chance to read the bill. Most of them didn't even know what was going to happen. And the ones that did question it, they were going to shut down. There was only 17 people that didn't vote for this bill. And, you know, I started off this video with Mr. Lundeen and his speech. He was one of those. And here you can see Mr. McFadden questioning it as well. And where are these assets that are going to come from that are backing these Federal Reserve notes if they can issue them without limit? And of course, all of the property in the country has been collateralized, and the only thing left were the people, which is why you have birth certificates. This is so easy to see. I don't even see how anybody could deny it. When you read what these guys, people need to actually stop, take the time, and read this stuff. So y'all can shut down all these naysayers and everything. It's right here. It's right in the open for you to see. These people, let me tell you why you need to read this. Because these people think you're stupid. They don't think you can read this and understand what's being said. It's up to you to prove them wrong. Mr. Britton, from my observation of this bill as it was read to the House, it would appear that the amount of bank notes that might be issued by the Federal Reserve System is not limited. That will depend entirely upon the amount of collateral that is presented from time to time from exchange for bank notes. Is that not correct? Mr. McFadden, yes, I think that is correct. It should be clear that the currency was no longer backed by gold, but by a promise to pay on various debt instruments, loans to private individuals or businesses, and the government. So there were no hard assets backing up the currency, only promises In the case of government loans, the collateral would be the full faith and credit of the United States. This is very strong evidence that the federal government was bankrupt at that time. If it weren't, the federal government would still be willing to pay its obligations in gold, and the currency would still be backed by gold. Who did the federal government owe money to? The obvious answer is the Federal Reserve Bank, who is holding the direct obligations of the United States. The Federal Reserve is a private bank. It is not a part of the government. The logical conclusion is that the government is bankrupt and the Federal Reserve is the creditor. The transition from a gold-backed currency to one that was not backed by any hard asset was very swift. The Federal Reserve Bank proposed it to President Hoover on March 3, 1933, and it was implemented into law by March 9, 1933. This is very swift action indeed. How can we account for such a rapid change in circumstances? We have not uncovered, at least thus far, direct evidence of undue influence by the Federal Reserve international bankers. However, their position as creditor to the United States does provide a plausible explanation as to why things change so rapidly. The final topic we will explore is the impact of this even on American citizens. Impact of bankruptcy. So let's clarify the difference between real money, backed by a hard asset, and a paper money substitute, Federal Reserve notes, FRNs. Federal Reserve notes, FRNs, are nothing more than promissory notes backed by United States Treasury securities, T-bills, a promise to pay the debt to the Federal Reserve Bank. They allow the federal government to create debt, which causes inflation through devaluation of the currency. Inflation occurs whenever there is an increase of the supply of a money supply in the economy without a corresponding increase in the gold and silver backing. Inflation is an invisible form of taxation that irresponsible governments inflict on their citizens. The Federal Reserve Bank has access to an unlimited supply of Federal Reserve notes. The Federal Reserve Bank only pays for the printing costs of new Federal Reserve notes. We also need to understand that there is a fundamental difference between paying and discharging a debt. To pay a debt, you must pay with value or substance, in other words, gold, silver, barter, or commodity. With Federal Reserve notes, you can only discharge a debt. You cannot pay a debt with a debt currency system. You cannot service a debt with a currency that has no backing in value or substance. No contract in common law is valid unless it involves an exchange of good and valuable consideration. What does the federal government have to offer the Federal Reserve in payment of its debts? The next quote answers this question. Patent. The money will be worth 100 cents on the dollar because it is backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people in the nation. Congressional Record, March 9, 1933. We see that the federal government has offered all of the private property in the nation to its creditor, the Federal Reserve. The government can offer the labor of the people of the nation. See our article on the Federal Reserve System to see how the IRS is used to collect money for the Federal Reserve. This quote is evidence that the government hypothecated all of the present and future properties, assets, and labor of their subjects to the Federal Reserve System. Hypothecate. To pledge property as security or collateral for a debt. Generally, there is no physical transfer of the pledged property to the lender, nor is the lender given title to the property, though he has a right to sell the pledged property upon default. Black's Law Dictionary, 5th edition. So the government has pledged, mortgaged our property as collateral to their creditor, the Federal Reserve. If you thought the only person who could mortgage a property was the owner, you are correct. The implication is that through some mechanism, which will be the subject of future material on this website, the government has taken over controlling interest in our property. If this is the case, it is a violation of the Fifth Amendment to the Constitution. Nor shall private property be taken for public use without just compensation. You may wonder how you got roped into paying someone else's debt. The answer can be found in the 14th Amendment. The validity of the public debt of the United States should not be questioned. The 14th Amendment, Section 4. After the passage of the 14th Amendment, everyone born in America became a 14th Amendment federal citizen. As such, you are held liable for the public debt of the United States, not the United States of America. To provide further evidence of government control of our property, consider the fact that we pay property taxes. Prior to 1913, when the Federal Reserve Act was passed, most Americans owned their property and had allodial titles. There are no property taxes in this situation. When we buy property now, we are not given an allodial title. Instead, we are given a title deed, which is not fee simple absolute. To better understand, let's look at the definition of these terms. Allodial, free, not holding on any lord or superior, owned without obligation or vassalage or fealty. Black's Law Dictionary, 5th edition. Fee simple. A fee simple absolute is an estate limited absolutely to a man and his heirs and assignees forever without limitation or condition. An absolute or fee simple estate is one in which the owner is entitled to the entire property with unconditional power of disposition during his life and descending to his heirs and legal representatives upon his death, intestate. Black's Law Dictionary, 5th edition. Deed, a conveyance of realty, a writing signed by grantor whereby a title to realty is transferred from one to another. Black's Law, 5th edition. Title deeds, deeds which constitute or are the evidence of title to lands. Black's Law Dictionary, 5th edition. From these definitions, it should be obvious that we do not have fee simple absolute title to our land. If we had an allodial title without obligation, no one would have the authority to tax the land. They would also not have a right to sell the property if the taxes weren't paid. But when the property was hypothecated, the government took the authority. The title deed is evidence that a title does exist, but the question remains, who holds title to the property? It would seem that the government has taken control of our property and then they lease it back to us for what is called property taxes. In return for turning over all the property in the United States, the Federal Reserve Bank agreed to extend the federal government all the credit, money substitute, it needed. Like any other debtor, the federal government had to assign collateral and security to their creditor as a condition of the loan. Since the federal government didn't have any assets, they assigned the private property of their economic slaves, the United States citizens, as collateral against the unpayable federal debt. They also pledged the unincorporated federal territories, national parks, and forests as collateral against the federal debt. For evidence of this, see the United Nations plaques in most of major national parks. You might say, I don't feel like an economic slave. If not, then why are most Americans mortgaged to the hilt and have little or no assets after all debts and liabilities have been paid? Why does it feel like you're working harder and harder and getting less and less? Evidence of your economic slavery is the fact that you pay Social Security taxes and income taxes. Remember that we said the federal government could also pledge the labor of the citizens. The federal government gets the benefit of your labor in the form of federal employment income taxes. What you may not know is that the federal government does not have constitutional authority to tax your wages. So the income tax is voluntary. See our article on income tax is voluntary. You volunteer to pay the public debt when you apply for a Social Security number and then give it to your employer when you file a W-4 form. If you don't believe it, find a canceled check that you have written to the IRS. Turn it over on the back. You will see that the check was endorsed for deposit in the Federal Reserve account. So your check to pay your income tax was deposited into the Federal Reserve, a private bank who's the creditor for the federal government.
And for anyone who doubts that your income taxes are all being absorbed by the Federal Reserve, I want to introduce you to the Grace Commission report. I don't know how many of you remember back when Ronald Reagan, during his presidency, he had this report done that revealed that 100% of your taxes go to the Federal Reserve. I saw a video where somebody's talking about where our taxes go to pay for other things. And right here in the report, it tells you where the taxes go. Let's take a look. And right here on page 12, you can see right here, with 2/3 of everyone's personal income taxes wasted or not collected, 100% of what is collected is absorbed solely by interest on the federal debt and by federal government contributions to transfer payments. In other words, all individual income tax revenues are gone before one nickel is spent on the services which taxpayers expect from their government. So, you know, I've saw some naysayers out there say, oh, those guys are crazy, our taxes go on this. Well, here's the Grace Commission report. And if you remember, it wasn't long after this report that Ronald Reagan was shot. Now, there's a lot of conspiracy theories surrounding that you can do your own investigation on. But a lot of you don't remember this. Some of you may be too young to remember this. I remember when it happened. But just do your investigation on the Grace Commission report if you are interested in where your income taxes are going.
In summary, the federal government is bankrupt. The Federal Reserve is the creditor to the federal government. All of your property and labor have been pledged to pay the debts of the federal government. As a United States citizen, you're held liable for the public debt.
This is a day of national consecration. And I am certain that on this day, my fellow Americans expect that on my induction into the presidency, I will address them with a candor and a decision which the present situation of our people impels. This is preeminently the time to speak the truth, the whole truth, frankly and boldly. Nor need we shrink from honestly facing conditions in our country today. This great nation will endure as it has endured, will revive and will prosper. So first of all, let me assert my firm belief that the only thing we have to fear is fear itself, nameless, unreasoning, unjustified terror, which paralyzes needed effort to convert retreat into advance. In every dark hour of our national life, a leadership of frankness and of vigor has met with that understanding and support of the people themselves, which is essential to victory. And I am convinced that you will again give that support to leadership in these critical days. In such a spirit on my part and on yours, we face our common difficulties. They concern, thank God, only material things. Values have shrunk to fantastic levels. Taxes have risen. Our ability to pay has fallen. Government of all kinds is faced by serious curtailment of income. The means of exchange are frozen in the currents of trade. The withered leaves of industrial enterprise lie on every side. Farmers find no market for their produce, and the savings of many years in thousands of families are gone. More important, a host of unemployed citizens face the grim problem of existence, and an equally great number toil with little return. Only a foolish optimist can deny the dark realities of the moment. And yet our distress comes from no failure of substance. We are stricken by no plague of locusts. Compared with the perils which our forefathers conquered because they believed and were not afraid, we have still much to be thankful for. Nature still offers her bounty, and human efforts have multiplied it. Plenty is at our doorstep, but a generous use of it languishes in the very sight of the supply. Primarily, this is because the rulers of the exchange of mankind's goods have failed through their own stubbornness and their own incompetence, have admitted their failure and have abdicated. Practices of the unscrupulous money changers stand indicted in the court of public opinion, rejected by the hearts and minds of men. True, they have tried, but their efforts have been cast in the pattern of an outworn tradition. Faced by failure of credit, they have proposed only the lending of more money. Stripped of the lure of profit by which to induce our people to follow their false leadership, they have resorted to exhortation, pleading tearfully for restored confidence. They only know the rules of a generation of self-seekers. They have no vision, and when there is no vision, the people perish. Yes, the money changers have fled from their high seats in the temple of our civilization. We may now restore that temple to the ancient truth. The measure of that restoration lies in the extent to which we apply social values, more noble than mere monetary profit. Happiness lies not in the mere possession of money. It lies in the joy of achievement, in the thrill of creative effort, the joy and the moral stimulation of work no longer must be forgotten in the mad chase of evanescent profit. These dark days, my friends, will be worth all they cost us if they teach us that our true destiny is not to be ministered unto, but to minister to ourselves, to our fellow men. Recognition of that falsity of material wealth as the standard of success goes hand in hand with the abandonment of the false belief that public office and high political positions are to be valued only by the standard of pride of place and personal profit. And there must be an end to a conduct in banking and in business which too often has given to a sacred trust the likeness of callous and selfish wrongdoing. Small wonder that confidence languishes, for it thrives only on honesty, on honor, on the sacredness of obligations, on faithful protection, and on unselfish performance. Without them, it cannot live. Restoration calls, however, not for changes in ethics alone. This nation is asking for action, and action now. Our greatest primary task is to put people to work. This is no unsolvable problem if we face it wisely and courageously. It can be accomplished in part by direct recruiting by the government itself, treating the task as we would treat the emergency of a war, but at the same time, through this employment, accomplishing greatly needed projects to stimulate and reorganize the use of our great natural resources. Hand in hand with that, we must frankly recognize the overbalance of population in our industrial centers, and by engaging on a national scale in a redistribution, endeavor to provide a better use of the land for those best fitted for the land. Yes, the task can be helped by definite efforts to raise the values of agricultural products, and with this the power to purchase the output of our cities. It can be helped by preventing realistically the tragedy of the growing loss through foreclosure of our small homes and our farms. It can be helped by insistence that the federal, the state, and the local governments act forthwith on the demand that their cost be drastically reduced. It can be helped by the unifying of relief activities which today are often scattered, uneconomical, unequal. It can be helped by national planning for and supervision of all forms of transportation and of communications and other utilities that have a definitely public character. There are many ways in which it can be helped, but it can never be helped by merely talking about it. We must act quickly. And finally, in our progress towards a resumption of work, we require two safeguards against a return of the evils of the old order. There must be a strict supervision of all banking and credit and investments. There must be an end to speculation with other people's money. And there must be provision for an adequate but sound currency. These, my friends, are the lines of attack I shall presently urge upon a new Congress in special session detailed measures for their fulfillment, and I shall seek the immediate assistance of the 48 states. Through this program of action, we address ourselves to putting our own national house in order and making income balance outgo. Our international trade relations, though vastly important, are in point of time and necessity secondary to the establishment of a sound national economy. I favor, as a practical policy, the putting of first things first. I shall spare no effort to restore world trade by international economic readjustment, but the emergency at home cannot wait on that accomplishment. The basic thought that guides these specific means of national recovery is not narrowly nationalistic. It is the insistence as a first consideration upon the interdependence of the various elements in and parts of the United States of America, a recognition of the old and permanently important manifestation of the American spirit of the pioneer. It is the way to recovery. It is the immediate way. It is the strongest assurance that recovery will endure. In the field of world policy, I would dedicate this nation to the policy of the good neighbor. The neighbor who resolutely respects himself and, because he does so, respects the rights of others. The neighbor who respects his obligations and respects the sanctity of his agreements in and with a world of neighbors. If I read the temper of our people correctly, we now realize, as we have never realized before, our interdependence on each other, that we cannot merely take, but we must give as well. That if we are to go forward, we must move as a trained and loyal army, willing to sacrifice for the good of a common discipline. Because without such discipline, no progress can be made, no leadership becomes effective. We are, I know, ready and willing to submit our lives and our property to such discipline because it makes possible a leadership which aims at the larger good. This I propose to offer, pledging that the larger purposes will bind upon us all, as a sacred obligation, with a unity of duty hitherto evoked only in times of armed strife. With this pledge taken, I assume unhesitatingly the leadership of this great army of our people, dedicated to a disciplined attack upon our common problems. Action in this image, action to this end, is feasible under the form of government which we have inherited from our ancestors. Our Constitution is so simple, so practical, that it is possible always to meet extraordinary needs by changes in emphasis and arrangement without loss of essential form. That is why our constitutional system has proved itself the most superbly enduring political mechanism the modern world has ever seen. It has met every stress of vast expansion of territory, of foreign wars, of bitter internal strife, of world relations. And it is to be hoped that the normal balance of executive and legislative authority may be wholly equal, wholly adequate to meet the unprecedented task before us. But it may be that an unprecedented demand and need for undelayed action may call for temporary departure from that normal balance of public procedure. I am prepared, under my constitutional duty, to recommend the measures that a stricken nation in the midst of a stricken world may require. These measures, or such other measures as the Congress may build out of its experience and wisdom, I shall seek within my constitutional authority to bring to speedy adoption. But in the event that the Congress shall fail to take one of these two courses, in the event that the national emergency is still critical, I shall not evade the clear course of duty that will then confront me. I shall ask the Congress for the one remaining instrument to meet the crisis: broad executive power to wage a war against the emergency as great as the power that would be given to me if we were in fact invaded by a foreign foe. For the trust reposed in me, I will return the courage and the devotion that befit the time. I can do no less. We face the arduous days that lie before us in the warm courage of national unity, with the clear consciousness of seeking old and precious moral values, with the clean satisfaction that comes from the stern performance of duty by old and young alike. We aim at the assurance of a rounded, a permanent national life. We do not distrust the future of essential democracy. The people of the United States have not failed. In their need, they have registered a mandate that they want direct, vigorous action. They have asked for discipline and direction under leadership. They have made me the present instrument of their wishes. In the spirit of the gift, I take it. In this dedication of a nation, we humbly ask the blessing of God. May He protect each and every one of us. May He guide me in the days to come.